Good afternoon.
Good afternoon, Your Honor.
Please be seated. Good afternoon.
Good afternoon.
We are here today on a long-scheduled request, consideration of a review of Mr. compliance and or concerns with his supervised release. First, let me ask if there's an entry of appearance here for the United States.
Jose Ortega on behalf of the government, Your Honor.
Thank you. And also, Mr. I see, Mr. Can you hear me?
Yes, I can hear you.
Okay. In our room here in Philadelphia, we have probation officers. If they would identify themselves, the probation officers are here with us. Thank you.
Your Honor, James Muth, M-U-T-H.
Thank you. And with you, the probation officer, I understand, in the Southern District of Florida?
Yes, good afternoon, Your Honor. Jeff Feldman on behalf of U.S. Probation in the Southern District of Florida.
Thank you for being there, sir.
Yes, sir.
Mr. We're here today on a request from probation concerning concerns on the supervised release. I start with a question to you, and that is, you do not have a lawyer today. You are, of course, entitled to a lawyer. When we were together before the appeal, you had standby counsel, Mr. Ibrahim. He was discharged. His service had ended. We then know that he was initially involved in the United States Court of Appeals in one of your appeals, and we know that on the record shows that as of August 17, 2017, the Court of Appeals relieved Mr. Ibrahim of his representation of you and allowed a request to appoint new counsel. Mr. Have you retained new counsel in the Court of Appeals?
No, I have not.
Okay, thank you. Do you wish to discuss these matters concerning the concerns of the probation office today without counsel, or do you wish to appoint counsel? And I leave it to you. I'm willing to do either one.
I believe your court deputy received an email from me concerning this matter. Were you not informed about it?
Sir, you have to file motions in this court. Writing to a courtroom deputy won't help anything. So just what's the answer? Would you like to proceed with or without counsel?
Well, I have no choice because my request for counsel was denied. I'm here now, and there's nothing more I can do about that.
Did you you mean from the court of, who did you request counsel from?
I informed your deputy that because you denied me ECF access, I would not be able to get you a motion in one day to get you to approve counsel for me. And he said, tough luck, deal with it, as if I didn't need the ECF when I asked for it. So that's why we're here today without me having a counsel, without me being able to formally motion you for a counsel.
Okay, so I'm asking you today, would you like me to appoint you counsel from the Eastern District of Pennsylvania, not standby counsel, but counsel, a lawyer that would be a person who would be your lawyer for purposes of supervised release, or you wish for me to discuss these issues concerning the anger management class and employment without a lawyer today?
If there's anything that would delay the proceedings, then I wouldn't consent to that. I should have been able to speak to an attorney prior to the hearing here today, but that was denied. So we're here, and we'll just move forward. I believe I am competent enough to deal with the situation that was forced on me.
Well, sir, let me. I don't want you to put a caveat on that. The issue is we will proceed we have a pending request for me to review the conditions of supervised release. I don't have a pending motion to appoint counsel, and I want the record to be clear that when we considered appointing counsel when I was in charge of the case in the trial court, you declined the right to have counsel and wished to proceed by yourself with standby counsel. You also requested the Court of Appeals to withdraw the representation of Mr. Ibrahim, and that was granted. You have not, that was on August 17. You have since then not found counsel. So, United States, do you have any concern in proceeding and addressing the issues on supervised release with Mr. consent to proceed on these issues anyway today without a counsel?
I don't, provided that the defendant waives his right to have counsel at the hearing. I have no problem.
Okay. So, Mr. you and I have gone through this process before, and I want to just make it clear to you that even in a supervised release violation hearing, certainly you have the right to counsel. I would recommend that you have counsel, that the counsel could assist you in, for example, understanding your options regarding whether there are other conditions that could be approached. I don't want to speak for counsel, but also addressing what could be worked out with the probation office in Florida. So I must ask you, knowing that having an attorney would serve as a benefit to you, and also knowing that appointing counsel will delay this hearing for several weeks at a minimum, I ask you, do you want to waive counsel for this hearing? For this hearing.
If this hearing is going to be delayed for several weeks, and then I don't. The issue that I have is when counsel was previously appointed, you appointed me a counsel who is friends with the same judge I'm accused of threatening. And when I noticed he was sabotaging my case and I requested to have him removed, you refused to do so. And then I don't even know if that's what will end up happening again if I just get appointed a counsel that's friends with individuals I'm in dispute with. So I honestly, at this juncture, I think that the hearing has to move forward. My family's here. We're going through a nightmare with you guys, and we need to get some closure. Whichever way you go, we need to understand where we stand. And I don't think a counsel is going to be able to help me if the laws are not being followed the way that it's happening in this case. I don't think any counsel can cure something like that. So I'm proceeding right now today.
Your Honor, I think if the court is going to accept that waiver, the court is bound to do a Pepper's colloquy of this defendant, even in a violation of supervised release hearing.
Right. I don't have. I'm going to have to take a minute because I'm not in my courtroom to get the full Pepper's colloquy.
I am fully aware of the Pepper's colloquy, and I don't have any issue with any of the considerations under Pepper's. I've gone through Pepper's colloquy multiple times in this court.
Right. You and I have gone through Pepper's colloquy several times. I would still prefer, for the record, reflect. Let me ask Mr. Ortega if Mr. understands, in your view, if he understands Pepper's colloquy, because his experience has been, at least he and I, and your presence, have done it at least 3 or 4 times. Are you comfortable with his waiver given his understanding of Pepper's colloquy?
Well, the problem, Your Honor, is that after the hearing, when Mr. sits himself in front of a computer and he goes through whatever mental process he goes through, he will ultimately file paperwork and make all sorts of allegations against parties, non-parties, and I'm concerned that one of the allegations he may raise is that this court denied him a Pepper's colloquy on the record, despite the fact that we have this representation on the record.
I will not make any such representation. The Pepper's colloquy wasn't denied by the court. I merely raised the history of what happens when I'm assigned counsel by the court, in terms of counsel being conflicted and not looking after my interests rather than the people I'm disputing with. So that's the issue I raised. I think that's what my concern is, and that is the concern that I do raise in the courts, because I will not get assigned any kind of counsel who won't be beholden to the court. Because if they go against the court, obviously there's no more career for any attorney who decides to do something like that.
I think, Mr. your last statement there warrants me giving consideration to giving you the Pepper's colloquy again. That statement, that is your belief. I have no knowledge of any such fact, and I want the record to be clear. I've not seen any evidence of that concerning any lawyer.
I think I filed a motion with you where I gave you the article concerning Ibrahim having cases under maritime, and I think if you remember correctly, I'm being charged with threatening maritime. So by implication, it's obvious that an attorney who's having cases in front of a judge that I'm threatening or alleged to have threatened is going to be concerned about doing things to, So I think that wasn't a motion that was submitted to you, and that's what I submitted. That's the type of issues that I have concern with.
I do recall that issue. Your concern was since Mr. Ibrahim appears before Judge Time, as he appears in front of judges all over the eastern United States, that he would have a relationship with Judge Time. I do remember that. Okay.
Yeah, and I think the reason we transferred the case to Pennsylvania specifically is to remove everybody involved in Delaware, and there's plenty of Pennsylvania attorneys who don't practice in Delaware who could have been assigned, but I was actually assigned an attorney that has a heavy practice in Delaware, so that's the kind of things that I take issue with. But aside from that, that's the issues with counsel.
All right, I'm going to hold one moment. We're going to sit in recess. I'm going to get my Pepper's colloquy. I'm not in my courtroom, Mr. I'm in a courtroom with a video conference capacity. So I appreciate your patience and your family's patience, and probation officer in Florida. Thank you, sir. But
Yes, sir.
Just give me 1 moment. We'll step down to have that colloquy. I think, given the concerns, you may understand the colloquy. You and I have been through it, but I think just to be careful for your protection, I'm going to do that. So let's stand down. Let's take an adjournment for just 2 minutes so I get the Pepper's colloquy in the room. Thank you.
All right.
Thank you. Please be seated. I'm going to give what you know as the Pepper's colloquy. It's a self-representation colloquy, just to ensure that we're all comfortable with you proceeding. Have you ever studied law?
No.
Have you ever represented yourself in a criminal action?
Yes.
Do you understand that today we are considering a violation of supervised release in connection with payment for or attending anger management classes and employment issues in the Southern District of Florida? Do you understand that's the concerns today?
Yes.
Do you understand that there are sentencing guidelines that I may consider in determining a sentence or for violation of supervised release if you're found guilty?
Yes.
Do you understand that if you represent yourself, you are on your own, that I cannot tell you or even advise you as to how you should try your arguments today?
Yes.
Do you understand there may be defenses to these two positions with which you are answering today? Do you understand you have defenses then?
Yes, I said it.
Thank you, sir. Do you understand that an attorney may be aware of those defenses that you are not of simply because he or she is a lawyer?
Yes.
Do you understand I cannot give you any advice about those defenses or ways to defend against these two concerns?
Yes.
Are you familiar with the federal rules of evidence?
Yes.
Do you understand that I may apply those federal rules of evidence today in part or in whole, and that you must abide by those rules even though you're representing yourself?
Yes.
Are you aware, sir, with the concept of supervised release and what it means?
A little bit, yes. Not today, because I really don't understand why I'm here, but generally before today, yeah, I used to know what it meant.
I mean, in other words, do you understand a supervised release is after you are released from custody, there's a period of time upon which the probation office supervises certain conduct of yours. Do you understand that?
Yes.
Okay. And those rules are set forth by a sentence that was provided to you by me. Do you understand that those rules of supervised release are provided by the court?
Yes.
Do you understand that you have to follow the rules of criminal procedure even though you're not a lawyer?
Yes.
Do you understand that you may, if you wish, call witnesses or ask questions, and you are not permitted to tell me anything other than what you would tell me under oath, unless you're arguing? In other words, you're going to tell me under oath what you wish to tell me in your own defense? Do you understand that? You're going to speak
Yes.
under oath to me? Do you understand that?
Yes.
Do you understand an attorney could more easily contact potential witnesses and gather evidence and question witnesses easier than you can?
Well, now that I'm free, probably not, but
Okay.
when I was detained, yes, absolutely. That's why I was having the problem with the attorney. He was refusing to do what he needed to do to defend me, so that's what the issue was when I was detained.
Okay. I've said this before, and I'll say it again. I think it's unwise for you to try to represent yourself today, even though appointing a counsel would require a delay of several weeks. You are not familiar with all the aspects of the criminal law. You are not familiar with all the aspects of a court procedure, particularly a hearing like this. And you're not familiar entirely with the rules of evidence that might apply today. And I urge you not to try to represent yourself. But knowing that what the possibilities and risks are, do you still desire to represent yourself and give up your right to be represented by a lawyer in today's hearing?
How long of a delay would the hearing be?
I would think it would at least be 6-7 weeks. At least.
All right, I'll do that. Let's do 6-7 weeks.
Okay? We'll appoint you counsel. Now, sir, I want to be clear with this. Understand that this person will be your lawyer, not standby counsel. They'll be your lawyer. Do you understand that?
Oh, no, I wanted standby counsel assigned.
Oh, no. That's different. That's different. That's why I thought maybe you and I had this would be a counsel appointed to represent you.
I'm under the understanding that I can consult an attorney as standby counsel, but that I can still defend myself. Anything that would restrict me from being able to speak on my own behalf would be something I would not be able to consent to. And if you're saying that you would assign me a counsel and then I'm muted and only the counsel can speak, I would have concerns for my freedom in regards to that. But I do believe that the law allows you to at least assign me standby counsel so I can speak to an attorney and then get advice about this issue that is being raised right now.
Okay. So, in fairness to you, I was not thinking standby counsel, and that will be longer than 6 or 7 weeks. I don't want you to be concerned. I know you'll be concerned if we're sitting in March and you don't have a lawyer. It's much more difficult to find standby counsel in the Eastern District of Pennsylvania when you're in Florida. I'm not saying it will be longer than 6 or 7 weeks, but it's more likely that it will be longer than 6 or 7 weeks because it's more difficult to find somebody to do that. And I can't give you outside time, Mr. But I'm going to try. Maybe I'll get somebody as early as a couple weeks, and we have to reset it. I just don't know. It's harder to do it with standby counsel than it is with regular counsel. I'm not giving you a time frame, but do you wish to take that risk? It might be 10 weeks or 3 months, something like that.
Yeah, I think that
Okay.
I don't have a choice.
Well, okay. I want you to be clear. You do have a choice, but you've made your choice. Your choice is you'd like me to appoint standby counsel to assist you in understanding.
Somebody other than Ibrahim, obviously.
Well, I can't appoint Ibrahim because he's on the court. The Court of Appeals says already. That's why he's not here today. he's out of the case, and there is no lawyer in your case presently.
Okay, but also the only other request I have is no attorney that has any connection whatsoever to the Delaware District Court, that does not have any contacts with lawyers or judges in that district, that could not have any conflict of interest, the things that would minimize potential conflict so that I could receive some genuine advice that actually may be helpful instead of harmful.
Mr. I can only tell you who's on our panel. You're getting the benefit of appointment from the Criminal Justice Act panel. As you know, Philadelphia sits 25 miles from Wilmington. Most of our attorneys on our Criminal Justice Act panel would practice pretty extensively in Delaware, as we would in New Jersey or in a suburb of Philadelphia. So I can't screen lawyers if they have a practice in the District of Delaware, since almost everyone does have a practice.
I'll do that. I'll definitely do that for you. You don't have to do any work on that. I will research any attorney you assign, and I will find out every single thing that they're up to before I accept them.
That's not how it works, sir. You don't get to choose. I have to choose. If you wish to choose, you can pay them. Right? If you wish to choose, you can find somebody and pay them. I have to go through the effort of finding somebody, and I can't screen 165 lawyers or so to find out who has never practiced in front of Judge Time. I don't know a lawyer that hasn't practiced, given her experience in Delaware, in front of Judge Time. So she's been there a long time. So I never have, but I was not, so I don't know anybody that hasn't, but I can't ask lawyers if they've never practiced in front of Judge Time. I may not find anybody. So I can't make that a condition, sir. I can't make it a condition that they've never practiced law in front of Judge Time. Or that they'll promise me they won't practice law in front of her in the future.
I think then that was a very good reason why we should have transferred the venue to an appropriate district, which doesn't have contacts with this judge, but that was denied as well. But in any case, I'll see who you assign, and I'll take it from there. I mean, I have no choice in the matter, is what it comes down to. So,
well, I don't. You're on the record here, sir. You're telling me you have no choice in the matter, but in fact you do. Your choice is you can proceed without an attorney, or you can proceed with the attorney I appoint. I cannot shop for a lawyer for you.
That's fine. As long as they're standby counsel, then I'm not forced to follow anything that they attempt to do or whatever. So,
well, and unlike the proceeding that you were in before, this today would have been about a 15 to 20 minute proceeding, and would have been over very quickly. But the issues in this hearing are nowhere near the issues that were involved in the case.
Just one thing, Your Honor. What I really didn't understand to begin with is why we even have a hearing to begin with. There was a sentencing plea colloquy where before I pled guilty, I raised the issue about employment, that I was fearful of employment, and you actually told me in order to induce me to plead guilty that I don't have to be employed. That's not a condition that has to be enforced. The concern for you, what you said in the transcripts, page 42 I believe it is, you said that really what it is, you want to make sure that probation knows where I'm at. And the only times probation has looked for me, I'm home. Either I'm home or I'm with my fiance. That's the only two places where I'm at. I don't go anywhere else. I don't do anything else. So that was your concern. And then the only other concern was the anger management, which I agreed to do. It just something wasn't, you never ordered me to have to pay for any condition of my supervision. So all I asked you for was clarification. I think that could have been done without a hearing, and I don't even know why we have that here.
Sir,
having a hearing.
Sir, I don't want to argue with you, but I can't respond to you without a lawyer. You want a lawyer, but you make very valid points. This is not my proceeding. I don't bring this proceeding. I'm not the prosecutor. The probation office raised concerns. I may very well agree with you. Okay, I'm not disagreeing with you, but I can't rule on this because you wish to have a lawyer. So. That may very well be correct. The probation office has asked for a hearing. I thought it more of a status conference. I wanted to sit and hear from you what's going on. But if you wish to have a lawyer to do that, I don't want to deprive you of that right, sir. And that's really what I was saying. This is nothing like, in some sense, what you were going through before. This is really a status conference to see what's going on your supervised release. But you're entitled
Okay.
you're entitled to have a lawyer.
I appreciate the honor. It's just that my understanding is that from the paperwork I read is that they were requesting for me to be in prison. So I actually took that very seriously. My family and I have been very distraught over this. We're very concerned about, and really the reasons they raised were false, because I never refused to attend any anger management. I never was required by you to get employment, and I raised valid concerns, being that I ended up in jail because of an employer, and I have concerns about not being protected from that kind of abuse, and I raised that in many instances in the court. And so there was, and I never, nobody in the history that I've ever heard of anybody ever have their probation revoked for not getting a job within 30 days. It's unheard of. It's unprecedented.
You may very well be right, sir, but you want a lawyer, and these are good arguments. But if you want a lawyer, I can't rule on that. So I'm going to have to adjourn this proceeding, appoint you a Criminal Justice Act panel attorney to advise you as to that argument. And you may wish to make any argument that we can arrange again, with the courtesy, of course, of the probation office and the court in the Southern District of Florida, who arranges this at their convenience and when they're available, and when we're available and you're available. So we have to get a lawyer and we have to reschedule it. So,
I appreciate it. I have just one question, Your Honor, if I may, please. Since we're here, I'd like to motion the court to see if the Southern District of Florida Probation Office could actually allow me to meet with an actual psychologist as part of whatever mental health protocols they have, so I can discuss some of my concerns with them, my anxiety, the things that are causing me a lot of the issues that I have right now, and get some professional feedback. I don't think we need to limit counseling just to anger management. There may be other issues that I would like, that I think that are worth exploring. Maybe a report could be made at some point if I desire one to be made. And so I don't think that that's an unfair thing, that maybe we can just, in the meantime, actually allow me to comply with one of your conditions by choosing any one of the providers that they're in contract with to do those things that they're requesting me to do.
let me hear from the United States, but Mr. I think that's a very good idea. The problem is, if you want a lawyer, I can't go any further. So, Mr. Ortega.
Your Honor, just something that I just thought of, and I'm asking the court to entertain it. I think what may happen, looking forward, if Your Honor selects a lawyer that is willing to accept the appointment, and given the defendant's research of that lawyer, he is unhappy with that lawyer, we will now be back to square one. I have a suggestion for the court, if the court is willing to entertain it.
Sure.
And Mr. Feldman may weigh in. The only guarantee of getting a lawyer that has no connection to Delaware or Judge Stein is if we get a lawyer in Miami. And the way to do that, my suggestion to the court, is to consider transferring the case to Miami, where the lawyer would be able to meet with the defendant in person, where the providers are actually located, rather than doing it at such a distance, because it's going to be very difficult, in my view, for the court to manage which lawyer fits his requirements. And then we're going to be back circling around this issue. And to me, in my mind, administratively, it seems to make more sense.
So your suggestion is to transfer supervision to Southern District?
Correct.
Well, Your Honor, if I may speak on that, actually...
Do you wish to speak? Okay, Mr. Carraj, I have to clarify. You're going to speak without a lawyer. You understand that, right?
Yes, but I've been allowed to speak and make motions without a lawyer, and I'd like to be treated the same way I was treated previously.
Okay.
If there's obviously a hearing, we're here, and I can make oral motions.
Sure.
Those don't need to be made with a lawyer present, because I'm here, I can make an oral motion. In terms of the hearing that involves the probation officer over there, we can delay that until there's a standby attorney assigned, and I consult with them. And frankly, if I consult with a standby attorney and I don't want to follow the advice that they provide, I will proceed on my own path, and that's the end of that. There's no need to deal with jurisdictional issues at this juncture, because I don't want to involve additional jurisdictions in a matter that's specifically on appeal right now in the Third Circuit, and I'd like to keep all the issues compact and clean for me to deal with instead of generating new cases, new jurisdictions, new judges that I've never met before. And that's why I don't want to be involved with any new judges. I've already had my full taste of the judiciary in this matter. I don't think I will get anything different than what has happened previously. And I think that at this juncture, there's no reason to transfer anything. The only issue is, we have a hearing for which there's no real reason, and they want to pursue it. So I'd like to just speak to an attorney.
Let me ask you this, without taking any evidence. Let me ask you this, Mr. Would you be, if I understand your suggestion to me, an oral motion, you'd be willing to consider a modification of your release so they take out the anger management principal component and deal with the probation office in the Southern District of Florida concerning seeing one of their contracted psychologists to help discuss that issue?
Absolutely. I offered, Mr. Feldman's right here. I told him that I would be willing to do that. I wrote the email. I said, submit an email to your court stating that I would love to do that. I actually am requesting it because I do have issues that are directly resulting from these issues, from this stalking that's being engaged against me. So I'd like to talk to somebody about that. And if they got somebody under contract where I don't have to give them $30 a week that I don't have and rob my family for that money for no reason, why not just get somebody who's contracted and have them handle that issue, and we can modify the terms right now. And that ends that whole issue right there.
Without taking any evidence from you, let me ask you, and you don't have to answer it if you don't want to, let me ask you this. On the issue of your, is your position that you will, as long as you're on supervised release, you will never seek employment? Or is it just at this, just at this stage you do not want to seek employment?
At this stage, I'm working on my appeal. I don't even have time to even think about something like that.
Okay.
Okay, so I haven't even got, and then I would like to also, if I do seek employment, I would only really want to work with my family and nobody else, people that I trust, things like that.
Okay.
And obviously, I've got to support myself. I've got problems of my own that I need to handle. I have to support myself. But I don't consent to being placed into any environment involuntarily where I could be subjected to another type of entrapment plot like what's been going on.
Okay.
And things that, in general, you already told me, and I raised this before pleading guilty, and you made it specifically clear that that would not be a consideration in your mind, that only thing you're worried about is knowing where I am. And I have no problem where Feldman will find me at any time he tries to find me, he knows where I'm at. And that will not be an issue, and Mr. Feldman's right here, and he will be able to confirm that to you going forward. So there's no problem.
Mr. Ortega, I do not want to rule upon the employment issue at all, given Mr. Cabaj's request for standby to talk to counsel about it. The issue on, I'm really not going to modify the terms either, since Mr. Cabaj has asked for counsel to discuss that issue. He's also.
I'm waiving counsel for that. I'm waiving counsel for those two issues. I'm fully completely voluntarily and knowingly, voluntarily waiving counsel for those two issues specifically.
Well, Judge,
for purposes of this hearing, it is as if I sent you a physical promotion requesting this relief. I don't need counsel for that, and I'm waiving counsel for that.
Back up a second, Mr. Let me be clear, because a moment ago. Tell me how you distinguish this in your mind. You wish that if we had a hearing that could result in a sentence or penalty, you'd want a lawyer, or you want standby counsel. Is that correct? That's one point, right?
That's okay. Obvious.
But if we have an oral motion by you to say, I'd like to consider modifying the terms of anger management to be a treatment with a psychologist contracted by the probation office of Southern District of Florida, you'd be willing to make that motion without a lawyer?
Absolutely. I'm making that motion right now.
Now, fully understanding the colloquy I just went through with you, you'd understand, you on that issue, on the motion, you'd be willing to proceed on that motion without a lawyer?
Yeah, absolutely.
Okay. Mr. Ortega, I'll go back to you. But the second question then is, there's a second component of this, and that is, do you have an oral motion concerning the employment concern? That is, what would be your motion concerning the terms of ever getting employment? Do you have any motion on that issue, or do you wish to speak to a lawyer on that?
The only motion I have on that issue is for you to enforce your prior orders, stating that I didn't have to in order to induce me to plead guilty. That's all. You're the one who stated that to me in order for me to plead guilty, and based on that consideration, knowing that I don't have to have that laying over my head where people will try to entrap me again, I pled guilty, or I would not have pled guilty, or I would actually, a lot of things you told me that didn't turn out exactly as was said, that, you know, but in any case, that's on the record. You can check the transcripts.
So, Mr. Ortega, let me turn to the United States on this.
Yes, sir.
Let's put aside the employment issue because there is a dispute there, and it seems that there's the oral motion is simply that there will be no employment condition, and I don't know the probation officer's position on that, but let's go to the first issue, and that is the oral motion. Mr. has waived his right to at least make an oral motion, which he's done throughout this case, to make an oral motion concerning modifying, in some sense reducing, the condition for supervised release regarding the treatment with a psychologist and through the mental health facilities in the Southern District of Florida, as opposed to specifically an anger management class, which is the words I used in the sentence. Does the United States take any position in opposition to that?
I don't oppose it, Your Honor, but my concern is I'm not really clear on what his position is about having a lawyer, because we're going back and forth, and he's having these streams of consciousness where he goes, lawyer, no lawyer, lawyer, depending on what you say to him. He will sometimes pursue a different trail.
Mr. I've got this. Mr. Ortega, I think I understand. I want to be clear. I understand the distinction being that Mr. if we're dealing with a penalty phase, that is a hearing for violation of supervised release, and we're not dealing with that, Mr. Ortega, that he is going to need a lawyer for that, a standby counsel. That's clear. What he's asking, though, in sort of on a side track here, is that he made a motion, which he's made throughout this case, without a lawyer, asking that we modify the anger management condition to allow it to be treatment. Mr. Feldman, I understand that you have some ability through contracted physicians or psychologists in the Southern District?
I do, Your Honor, and I also would like to mention to the court that I have a written waiver in front of me if the court would be more comfortable with him signing one of our Probe 49s,
right,
which is a written waiver,
right,
if the court should so request.
Okay.
And yes, we do have the ability to refer him to psychological as well as psychiatric, which would be a combined assessment for him, but Mr. would have to comply with any recommendations that the program does give us.
And that form, does that form address both psychologists and psychiatrists, do you know?
The way the condition is drawn up down here, Judge, it just specifically talks about mental health treatment.
Okay.
So it would encompass psychological and psychiatric.
Okay. So, Mr. Ortega, I'm willing to hear from, if your probation officer wishes to address it, and tell me what any concerns they may have in doing that. Put aside the hearing for a moment, the penalty phase for a minute. In a sense, I would defer that, right? I would adjourn that and defer that. And if there was a problem that I heard from the probation office later, I would bring it back. But is there an issue from your office, from the probation office, in that type of modification? Just give me 1 minute, if you would, as well. I'm sorry, ma'am.
Your Honor, our office would have no issue with modifying the conditions.
Right. So, I'm not, I'm not asking the probation office to withdraw their petition, Mr. Ortega. Let's be very clear here. What I'm saying is, I'm going to defer, adjourn this proceeding on the violation hearing. Mr. has made clear to us that he would like to have counsel, at least standby counsel. I'm not going to appoint someone right away for that, for the very reason that you suggest, that we'll be going around in a circle, maybe. And so the thought is this: if the probation, Mr. Feldman, do you have any objection to that? You raised the issue of getting that signed form. Apparently, you think you would recommend that as well, the signed form that you have. Okay.
Yes, I would. If Mr. is willing to waive his rights to be referred to a mental health program, I think that would be an excellent solution in the interim.
Right. And Mr. You did just tell me you're willing to do that. That's correct?
I'm willing to do that. The only conditions I have is that I'm allowed to record my sessions with anybody that they assign me to participate in counseling with. And that's it.
Mr. Feldman, we don't do that here, Mr. Feldman. I don't know. Is that a condition that's accepted there?
I don't think so, Your Honor.
Mr. You can't add conditions to it. So as your condition is modified, I can't. I thought we had an ability here to resolve the problem for you, but if you want to tape sessions that you have that are private sessions.
Well, the reason I say that.
I know the reason. I know why
because
you say that.
Whenever I tell something to a psychologist, they lie in their reports and say something different,
Fine.
and so I don't understand why it's a problem to record that. As a matter of fact, my hearing before Judge Lorette, he specifically told me that I'm allowed to record the hearing that I had with Dr. Biscanian. That wasn't a problem then. Now it's all of a sudden an issue. I don't understand why. I mean, it's just for my protection. I don't need to actually use the recordings for anything unless it's to dispute something that they write in a report which is false. And I think you, Your Honor, would want to be able for me to retain that ability to dispute something that might be false, unless we're attempting to pursue, indictments of me that are not true, and false testimony regarding me that's not true. So that's the only reason I say that.
Okay.
And it's for my personal protection that I would like to just be able to record sessions with people so that I can be able to affirm what I told them in case they say something different in a report.
Mr.
Because in everybody's interest.
Your motion is modified, is denied. I cannot allow a condition that people who are trying to help you outside, remember this is in supervised release, outside of any kind of charge, has nothing to do with any kind of charge against you, which was before, understand the distinction, I cannot require that conversation to be taped. This is to your benefit.
I'm not asking you to order it to be taped. I'm just letting you know that when I walk into a session with somebody, I'm going to bring my own, either my cell phone or something, and I will personally record it. There's nothing that the court needs to do or anybody else needs to do. What I'm saying is that if there's a discrepancy in a report written by a psychologist, I may bring evidence of a recording that could be then submitted to the court so that we don't have to deal with lies in the record. That's all. So I'm not asking the court to order recordings. I'm just saying that let's do the evaluations, but I would let the court know that I'm going to personally bring my phone and just record what's being said.
Well, Mr. I don't know the law in Florida on that, Mr. Feldman. I don't know if you do, but certainly we would not allow that here. I would not probably admit that evidence here. In fact, I'm sure Mr. Ortega would tell me that unless the psychologist or mental professional consented to the taping, it wouldn't be admitted, certainly in this court in Pennsylvania. So that's illegal in Pennsylvania.
Well, hold on, but Your Honor, the issue, we've already actually gone through this, where we've had hearings, and the hearings were supposed to be audio recorded, and then they were not, and then omissions and tampering of the transcripts was done, and that's a concern. I mean, obviously, even my family witnessed that directly. They had to send affidavits to the court and have transcripts changed because you guys took testimony out, when all I needed was the recordings. And the recordings would say what was in and what was not. So if the only thing that we're doing here is preventing me from just documenting facts so that we don't have fact disputes in the court, why would that be in the interest of the court to pursue in that or to proceed in that way? It doesn't make any sense. I mean, I'm very concerned. 5 times, Your Honor, 5 times I was sent to a hospital accused of schizophrenia based on false testimony provided by doctors. Is that not a concern that I would want to protect my interests and make sure that a doctor doesn't say that I said something that I didn't, or doesn't accuse me about delusion, about something that I said that is factual, which I bring evidence to a hearing and show them, and then later they say, well, no, that's delusional? I mean, that's all it is. Why would somebody want to deliberately destroy a record that just protects everybody? It protects the doctor, it protects the court, it protects everybody.
Let me ask you.
I wish the doctor did.
Is that enough, Mr. I'll ask the
Is
probation
this
officer.
hearing being recorded, by the way? I'm sorry. Is this hearing being recorded?
Sir, there's a court reporter here. There's a transcription being here. You can order and pay for the transcript. Yes.
But there's no recording?
There's
No
never
audio
a
recording?
it's a transcript, sir. There's not a
Yeah,
recording.
but you...
There's not a recording. There's not a. Oh, it's recorded here today.
Yeah, is it being audio recorded? Is the audio recording equipment active?
Yeah, it's not an audio recording in the way you think of, sir. It's a recording. Let me just turn to Let me turn to. I'll get you back in 1 second, Mr. Let me turn to the probation officer. Have you, as this district, ever authorized in your judgment allowing a supervised release, personal supervised release, to bring an audio recording into a meeting with a mental health professional?
Absolutely not, Judge.
How about in Philadelphia?
Your Honor, I've worked here for 21 years and I've never heard of that.
Yeah. Yeah. The motion has denied. The motion is requested to, telling me that you're going to bring that your condition, as you said, is that you were able to take the session with the mental health professional. With that condition, the motion is denied. I can't.
Okay, I waive that condition.
So you will not audio tape the session with the mental health professional.
No, I will not.
And you will have no. Just be clear, you have no recording of those discussions with Mr. Felton. When you agree to go to these persons, you will not record those sessions.
No, I won't.
Mr. Feldman, do you know the persons that are on this list? Have you dealt with them in your experience in the Southern District?
I have, Judge. I've dealt with the. I believe that we refer people to Compass mental health systems, and it's a fairly popular program.
Okay. Let me clarify for you, Mr. one thing, and I want to just talk to my deputy, because I want to make sure, I think you and I are talking by each other about what audio recording means. You are concerned about an audio recording of this session. Now, this session is recorded. Okay?
It's audio recorded.
Audio recorded.
Okay.
Okay? There is a transcript that could be ordered and purchased of this session. Now, how long do we keep it? Now, the question is, how long do we keep it? Okay. Yeah, that's right. Okay. Just to explain to Madam Deputy, when you have a court reporter alone, this is something called electronic sound recording. When you have a court reporter, a transcriber, they are not recorded. They kept, okay, in this court. However, this is electronically sound recorded, and if there's an audio recording from which a court reporter would take the audio, if you wanted the transcript, would take it and listen to the audio recording. Do you understand, sir?
Right, I understand that, but there are 8 hearings where I attempted to retrieve the audio recordings, and the court is saying that they're destroyed.
Well, I don't know anything about whether being destroyed. That was not mine. But any transcript where there's a court reporter in the room, somebody taking a transcript, there would not be an audio recording.
Okay, well, I was told differently by the Judge Lorette and other members of the court.
Well, in any event, I'm going to take under advisement the motion by Mr. I understand the United States position concerning. We are certainly not going to rule today on the violation hearing. What I'd like to do is defer on that rule, on that violation, and consider, Mr. Feldman, with your good efforts, consider modifying to allow Mr. through your efforts to meet with the contract. I would ask you, though, to have that document signed, the form by Mr.
Judge, I'm sorry, Judge. I can have it signed right now and email it to courtroom deputy while court is in session.
That would.
I have it on I have an electronic version of the form right here, ready to go.
Okay, that would be helpful, just so I could represent that Mr. has agreed to this.
I gotta read this. Give me a minute.
I'm just showing it to you.
Okay, so Mr. do you want to sign that document?
Can I read it?
Sure.
Okay, yeah, I don't mind signing this. The only thing that he said here, which is the issue that brought us here to begin with, he states the defendant will contribute to the costs of services rendered in an amount determined by probation officer based on ability to pay or availability of third-party payment. What I would request is that this payment be waived, and I will comply with I will sign this right now. It's not a problem.
Mr. Feldman, I
Based
don't
on
know.
your current, based on his current income, his co-payment would be waived.
Okay. So we'll put on the record that the co-payment is waived.
Signed, sealed, delivered.
Okay. I will consider the motion presented by Mr. who waived the right to have a lawyer to advise on that motion. I will not rule on the violation hearing at this stage. Mr. Ortega, I'll turn to you for any further concerns the United States has at this stage. I still have to just deal with the employment issue.
You're right. I think that procedurally, if we're going to modify the anger management portion of the petition of the supervised release, then going forward we can't proceed on a violation on that part of the
We may
petition.
not. What I'm saying is I may defer. You're absolutely right. I may defer, and I want to see if it actually happens.
And the only other thing, Your Honor, is I just want to make
Hold on,
sure
Mr.
that...
one second, Mr. I'm still in the United States.
Judge, I'm wondering if the court would consider dismissing the petition and then refiling a new petition based upon any violations of the modifications.
Including the employment one? Okay. I would consider that. That would be cleaner, and I think it'd be preferred by me. I did not want to do that without hearing from Mr. Did you have any objection to the dismissal of the petition against you?
It shouldn't have been filed to begin with, Your Honor.
So is the answer no objection?
Absolutely not.
Okay. Now, any last questions for you, Mr.
I'd like a copy of the transcripts for today's hearing, please, at expense of the court. And the only other issue I have is there was in the filing made by the probation officer, she placed my mother's address and phone number on the document. I'd like that redacted off of the document, please, because I don't like people knowing where my mom lives. We've had a problem with people stalking us there and sending her threats over there. And so things that are appearing in the court record, the people who are stalking me access the court record and then obtain this information and start using it to try to provoke more problems and stuff. So I think as a safety issue, I'd like that redacted off at the end of the document. Please.
The document that's is there a filed document that has?
I believe it was the petition. It's probably one of the last pages, somewhere in one of the last pages. There was an address listed there on Road, and I'd like that address redacted from
I think he's talking about the information sheet, Your Honor.
Yeah, from whatever appears on PACER, which is available to the public.
Page 4, Your Honor.
I'm sorry, Mr. Ortega, I don't see it. Where do you say this? Page 4?
Page 4, it's on my copy.
Oh, I'm sorry. Last known address and phone number?
Correct.
Yes, correct.
Yes.
Okay.
Please.
Is that document? Is that document? I don't.
It's document number 171.
171. Okay, I don't have the date stamp number. That's I don't have I don't have that number. Okay. 171. Well, we don't redact filed documents, sir. But your point, but that is your last known address. I mean, we cannot proceed without having your last known address. I mean, your address is of a person under supervised release is public information.
But no, I actually changed my court address to Park Boulevard. That's the address that I'm using in the court. My mother's address doesn't need to appear in the court. That's my mother's address.
Ms. Colon, is that you have that address? Where'd you get that address from? Where is this Florida address?
That address is the last known address. That's where he's currently living at.
Mr. Feldman, is that the current address he's living?
Yes, Judge, he lives with his mother.
Okay. Well, I can't redact that, sir. That's your address.
That's not my address. I'm staying with her because I'm stuck here against my will. I'm not a resident of the United States, so I'm just temporarily here until this issue is resolved.
Okay. All right.
And as you're aware, well, hold on a second, Your Honor, because of the history of the dispute, as you're aware, and my mother submitted affidavit, she's here, she received threats at her location because of this. This is a problem. This is a problem that we've been having. And that's why I'm asking the court to take into consideration our security as well and our concerns with being threatened and stalked and harassed by people who don't want to punish us because of our religion. And so we have an issue with that. This is not a public address. We do not file any pleadings with the court, receive any mail from the court at this address. This is my mother's private address. I'd like it for her security and safety, and so if we don't have any other issues, to simply be redacted from the record, as would a social security number or something in that regard.
Right. That's exactly the distinction, sir. The motion's denied on that basis. If that's your address, that's your address. If you do not wish to make it public, then but you certainly should do whatever you need to do in terms of if you feel like you're being threatened in southern Florida, let Mr. Feldman know and let the authorities know in Florida.
Yeah, we saw how that worked out, Your Honor.
I will consider the motion upon the United States request to dismiss it. Should I modify the terms of supervised release? If I do not, then I will Then I will try to set a CJA attorney for standby counsel. But I want to consider very carefully how we word a supervised release order. Mr. Feldman, if you would be kind enough to send it up to me, at least then I'd be able to have the form. Send it up to our deputy. Then I at least have the ability to have that form to incorporate in my order.
Yes, Judge, it's already in Mr. Muth and Ms. Cologne's mailbox, ready for them to submit it to Your Honor.
Well, Mr. I appreciate you coming in, and Mr. Feldman, I appreciate you coming in. I'm hopefully we made some progress today, and we can put this behind us if I can see the right paperwork and go forward. Thank you very much.
Can I just say one last thing, please?
Yes,
I just wanted to make sure that anything I said here today does not in any way waive any of my rights to appeal the entirety of the sentence and anything that was done in the district court proceedings. And I'm not waiving any of my rights in regards of my disputing the entirety of the sentence.
The only thing you waived today was the right to make that oral argument concerning the modification of supervised release. You agreed to do that yourself without a lawyer.